Hey everybody, Silvino Edward Diaz here for EPGD Business Law and Starving Artists. Starving Artist is the innovative subscription service for artists, creatives, and entrepreneurs. We assist you in all your business-related needs. I want to speak to you today about a topic that really is relevant to any industry, and that's the topic of trademarks. The first thing you need to know about trademarks is that, contrary to popular belief, you don't technically need to register a trademark for it to be your own. Trademark laws in the United States provide that the owner of a trademark is the entity. It could be a company, it could be a person, who first uses the mark in connection with a specific set of goods and services. Now, backtracking a little bit, we first need to know what exactly constitutes a mark. And a mark is basically an indicator of origin. So there's a distinction between a trademark and a company name. So you can incorporate a corporation and assign it a given name, but you may do business as a different trademark. Like, for example, Coca-Cola is a company, but within the Coca-Cola company, there are several different trademarks. Like, for example, you look at a red can with white cursive, and you automatically think Coca-Cola. So that is a trademark, in the same sense that you go to a theater and you watch a commercial with polar bears drinking a bottle of Coke, and that is also a trademark related to the brand. So one single brand, one single company can have many trademarks, and trademarks are indicators of origin. An indicator of origin basically is telling you, when you look at this item, it could be a sound, it could be a logo, it could be a phrase, it could be a name, you're automatically going to think about this product or service. So anything that can indicate the origin of where those goods or services come from can technically be a trademark. So going back, the owner of a trademark is the person who first uses the mark in connection with its goods and services. However, you shouldn't rely on that use exclusively, because things can get complicated when you find out that a competitor or somebody else is using your mark or a similar mark in relation to their goods and services. So what you want to do when you set up a company and when you know what indicators of origin you want your customers to associate with your products or services, you want to register that trademark. My recommendation when considering when and where to register a trademark is you want to think big picture. And while different states within the United States provide for trademarks to be registered within their respective departments of states, when you register a trademark within a state, you're only going to get coverage, trademark protection inside that jurisdiction. And that may not be enough if you're dealing with e-commerce companies, or if you have customers that are going to be visiting your webpage or going to be associating with your brand out of the state where you do business. So to me, the best recommendation I can give for anybody that wants to register a trademark is to do it within the U.S. Trademark and Patent Office, the USPTO. And what that's going to give you is going to give you coverage nationwide. Now, obviously, it's a bit more comprehensive a process to register your trademark nationally versus a state, because obviously there are a whole bunch of brands and potential competitors that are also going to be looking to protect their goods and services. But it's probably the safest way to go, and you're going to get several benefits out of registering your trademark versus simply having your brands out there and not getting a trademark certificate. The first benefit you're going to get is that that certificate is going to be prima facie evidence that you are the owner of a mark. And prima facie evidence, what it means is that it's first-hand evidence. You don't really need to prove anything beyond the certificate. Now, that can be a big benefit, because if you find out a competitor or somebody else is using a mark similar to yours or identical to yours in connection with their goods or services, it can be very hard and very difficult to prove to them, number one, that you own the mark, and number two, that you've been using it before them. And that requires kind of a fact-intensive, investigative sort of efforts so that you provide them with evidence. And even that will not necessarily be persuasive to them. So what you want to do is you want to make sure that you have a certificate that provides that first-hand evidence that you are already the owner. Now, something to keep in mind when registering a trademark is that you register per application. You need to choose not only the specific indicators of origin that you are seeking to register, for example, a logo, a slogan, a sound, but you also want to designate a specific category of goods and services. Now, this is very important to keep in mind, because sometimes when we think about registering trademarks, we think, okay, I'll register my trademark and then I'll have, entire ownership of this mark for all businesses, and no one will be able to compete with me on this mark. Well, that simply is not the case. Like, for example, computer brand maker Apple doesn't have a monopoly on the fruit apple. So those are two distinct goods and services, and one cannot compete with the other. So it's very hard for one to reach the other, and for one customer who's going to purchase apples to think that, well, by purchasing a computer, they're going to be purchasing the fruit. So that's the kind of consideration that you want to give when deciding, what am I going to register and what kind of goods and services am I going to be providing? Because application costs are going to go up to the extent that you continue to select additional goods and services and additional marks for your brand. That being said, sometimes you have a business where you're going to start doing business in the future, but you want to protect your brand now because you want to make sure that once you hit the market, that you already have that prima facie evidence on your favor. So trademark law provides that a future user of a mark in connection with their goods and services can seek trademark protection by issuing what's called an intent to use application. And that simply means that you intend to use the mark at a future time, and once you do that, you'll be able to tell the US Patent and Trademark Office, turn my mark into principal register, so that you already know that I'm using this mark in connection with my goods and services. Now, this has been just a tiny primer on trademark laws. Obviously, there's a lot more nuance and developments that we can get into, but I just wanted to provide a general sense of what the law is and what you can do right now to both protect your mark and make sure that you are doing everything you can to select those goods and services that are in connection with your mark, and start organizing yourself so that you can get those applications out there and make sure that you have that certificate, because that's going to be a big benefit to you, to your customers, and to your business. So this has been Silvino Edward Diaz with EPGD Business Law and Starving Artist. You can look us up, EPGD Law. You can look us up on social media. You can look us up on our web. Go to our social media, Starve Artists, and our website. Check out our services, and stay tuned for more videos like these. Thank you, guys.